Hello, everyone, and welcome. My name is Carla Ferstman. I'm the director of the Human Rights Center. I'd like to warmly welcome all of you to the annual lecture of the Essex Human Rights Center, and thank you for joining us online. The Human Rights Center is an award-winning interdisciplinary center, which is situated within Essex Law School. The center was established in 1983 as one of the first university-based centers dedicated to the advancement of human rights protections worldwide. Since that time, the center has developed an array of specialist academic programs, has produced groundbreaking research, and has partnered with local, national, and international policymakers to make the widest possible practical impacts on the global respect for human rights. The annual lecture is a rallying point for the Human Rights Center, and it serves as a vehicle to bring together our diverse community to discuss key issues and to engage with our invited experts. This year is no exception. This year, the human rights situation around the world is dire. In fact, it's hard to imagine it getting any worse. And we continue to grapple with human rights as a discipline and a methodology to solve what seem like intractable problems. As a university, we're critically engaging with these challenges. We are constantly considering what human rights includes and what it excludes, who it excludes, and why. And we're constantly analyzing how human rights standards can be better applied. We recognize that human rights is a crucial means through which we can show solidarity with those who are suffering from abuses and indignities around the world. And it provides us with a framework to demand that states and other actors respect, protect, and fulfill their human rights obligations. And this is something that we now, wearing the activist or practitioner hats, will continue to demand. Accountability for massive violations of human rights is a big part of this lexicon on human rights. In law, we recognize that accountability for the worst violations is mandatory. So not only do the victims deserve justice, the human rights machinery recognizes that impunity for massive violations is simply not an option. Clearly, we're very far from realizing these principles in all situations. However, over the past few decades, there's been an explosion of new mechanisms designed to end impunity for international crimes, some of which we are researching as part of our new LLM program on international criminal law that started this year. Foremost amongst these accountability mechanisms is the International Criminal Court, which began operations in 2002. Now this leads me well into the topic for today's annual lecture, and our topic is accountability for mass atrocity crimes, a human rights imperative. And I'm so delighted that we have with us today Judge Iulia Motoc from the ICC and Dr. Matthew Gillett from Essex Law School to discuss these issues. Before handing over to them, let me briefly introduce them. Welcome both. Judge Motoc is an International Criminal Court judge with the pretrial division. She is from Romania and was elected as a judge about 1 year ago and will serve for a 9-year term. Prior to joining the ICC, Judge Motoc was a judge at the European Court of Human Rights for a decade between 2013 and 2023, and also professor of international law. She also served as a UN Special Rapporteur for the Democratic Republic of the Congo, reporting on crimes against humanity and war crimes, and served as a judge of the Constitutional Court of Romania. Judge Motoc has extensive experience with various legal systems. She was a member and a vice president of the UN Human Rights Committee, examining the right to life, enforced disappearances, and other massive violations of human rights that are also within the competence of the International Criminal Court. She was also a member and president of the UN Subcommission on Promotion and Protection of Human Rights. She co-drafted the UN report on free, prior, and informed consent, of Indigenous people and the UN guidelines on extreme poverty. Dr. Matthew Gillett is a senior lecturer at Essex Law School. He's also the chair rapporteur of the United Nations Working Group on Arbitrary Detention. Prior to joining academia, Dr. Gillett served as a prosecuting trial attorney and appeals counsel with the International Criminal Court and the International Criminal Tribunal for the former Yugoslavia. He has also conducted investigations in various conflict zones, including as a human rights officer with the United Nations Assistance Mission in Afghanistan. Dr. Gillett has published widely on matters relating to international law, peace and security, and the environment. Dr. Gillett will engage Judge Motoc in conversation about her work and her perspectives on justice and accountability. Afterwards, there will be an opportunity for questions and discussion. So I encourage anyone who has any points they would want to raise to place them in the Q&A so that we can take them up towards the end of the lecture. Now, Matthew, Dr. Gillett, it's over to you.
Thank you very much, Professor Carla Ferstman, Carla, for the introduction. And thank you to everybody for participating and being here on this subject, which is one of obviously personal interest, but I think it's also one of global interest, where we're looking at how accountability mechanisms can play a role, not the entire role, far from it. I don't think anyone would pretend that these are a complete solution to any of the conflicts that are raging around the world, but nonetheless can potentially play a distinct role in ensuring that there is not pure impunity for the various acts that we see around the world. And with that thought in mind, we're very glad to have someone here with experience, of course, at the International Criminal Court, but preceding that, as you've heard, in a wide range of human rights positions, which will allow her, in our view, to give a perspective that is very broad, but also quite deep on these matters. So we're really glad, and thank you again, Judge Motoc, for joining us today and to engage in this conversation. Now, the questions I've got, I'm trying to adhere to my practice at the court. I'm trying not to ask leading questions. I don't know the answer to these questions, so I will pose them openly, and we'll see where the conversation takes us before, as mentioned, we'll have the opportunity to address questions from all others participating. So with that, I wanted to start at the outset and take you back to your formative years in Romania, where you grew up, as I understand, under the Ceausescu regime, and ask whether that had any impact in developing your interest in human rights, justice, international law more broadly. Over to you, Judge Motoc. Thank you.
Thank you very much for inviting me. And I have to say that when I started my activity as expert in the subcommission for the promotion and protection of human rights, back in the 90s, I had the pleasure to work with members of the Essex Center of Human Rights, with an expert for the center, Francois Ferstman, and with the assistants that were with the Center of Human Rights for Essex. So it's related to the beginnings of my activity. Starting back, I think your question is fundamental, because indeed, I was educated during the years of the Ceausescu regime, and here we have a simple answer and a complex answer. And the simple answer is, of course, I grew up in a totalitarian regime. I also have written a lot about, I think, the philosophy of the political legitimacy of this regime. This political regime was a weak one, but still communism has the totalitarian faces. We are not so keen to recognize even our days. So when we talk about totalitarian regime, we are looking more to fascism and less to the forms of communism as totalitarian regime, the form that I lived in Romania and several other countries for Central and Eastern Europe were, and still we have nowadays. So of course that growing up in such a regime without with the protection of human rights only on the paper, you have a certain sense, and with no freedoms, you have a certain political freedoms and civil freedoms, you have a certain sense of justice. You have a certain sense of justice, and you have a certain sense of justice almost related to the past, because you have the parents and the grandparents talking you about the moment where the regime was imposed by the Soviet in the 40s, where property was taking or life changed completely. So you grew up with the narrative for your relative. You also, I have one of my parents that were in the Gulag, so you have this kind of revolt against a totalitarian regime and this sense of justice that you have for, and this fight for human rights. But this will be, I would say, the first a little bit simple aspect. Simple because, you know, you say you up in a Ceausescu regime, you have the sense of justice. Communism and totalitarianism, it's a little bit more complicated. Here we have a lot of thinking in political philosophy around, but still not so complicated. But I think the second part, which is more interesting of growing up during the last year of a totalitarian regime, of Ceausescu regime, is that the communist regime was, and this area I studied as well as a professor, the communist regime was, after the 60s, became to be a very weak regime. It means that the past political legitimacy were out. It means that nobody believed anymore in a social area with equality, with perfect, no property, so on and so forth, because they were not there anymore. So the regime was looking for other legal basis, other legitimacy more than this. And the legitimacy of the communist, the socialist regimes in the 70s start to be a nationalist one, and we see even nowadays the influences is a lot to talk about this, but also a very interesting one that happened in Czech Republic with the philosopher Patočka, in my country as well with Konstantin Neuka. It means that in order to encourage us not to manifest ourselves in an ethic way against the regime, not to seek justice. This was to assert we were encouraged very much to look to the aesthetic part of the life. It means that we grew up in very much, we had a lot of philosophers that were more philosopher of the 30s, like Heidegger and all these philosophers, but also with them, we grew up very much into literature, philosophy, paintings, and everything. So a huge general culture. So this is the Weltanschauung where I grew up. And I think, you know, on one side, of course, you are in a totalitarian regime, and international public law was just diamat, nothing that propaganda. So where I have to study abroad, it was very difficult for me it was not so difficult, but I had to catch up to whole topic that I have never learned. So, but on the other side, all the books that I read and everything, I think, were maybe more important for me in my career than my legal studies.
And with this totalitarian regime eventually collapsing, and obviously there was quite a dramatic trial that is historically now known as a show trial of Ceausescu and his wife. How do you now perceive that decades on in retrospect? And particularly, it's interesting that one of the charges I saw was genocide against these individuals. So both legally, but also I think politically, and as you've noted, philosophically, I think you studied philosophy. It's very interesting to hear your reflections on that manifestation of the transition away from that regime.
Yes, of course, now we know very well that this was not a trial, this was a summary execution, basically. We know very well We know very well that it was not an investigation, that they were not even heard, that nothing really happened there that was related to a trial. This is very clear for all of us today. Even the lawyer that they were accused about genocide, about 6,000 people, because these people, they were supposedly during all the regime, somebody that they were dead or hungry and everything. What is very interesting, maybe you know that related to the event in 1989, the European Court of Human Rights had a very important case, 21 of December 1989, when they criticized Romania because we have not go through the investigation of the event in 1989, meaning with the revolts and killing of Ceausescu and everything, not into the trial, but on the events that were around. So by that time, I have to say that it was very interesting for us, because I think that almost nobody in the country, and I mean all these highest intelligentsia that I said that were so knowledgeable in Plato, Aristotle, and everything, was aware about this, because because we had a censorship, we didn't have any books on human rights or nothing, or genocide or things like this. We lacked completely. So our culture in political science or even discrimination or human rights was zero. So what we saw, and I was quite young by the time, but still I was a graduate of the School of Law. But I will talk about the other. It was only that we had the events in following the failed of the regime, the last year of the regime, which was very bad, and the fact that before, because it was a very strange, I will not define them, but of course we have to find the truth. Maybe we are going to find the truth, as the European Court of Human Rights told our country. So the events are such that this trial and this shooting actually of Ceausescu was presented as the only solution. So of course that immediately after when I went to study in France, I realized after my first year, and I realized maybe even before when I start to study, but by that time it's interesting that there were very few voices in all these very high intelligentsia that we had in the country, as I said before, so well educated in so many artistic fields, in so many philosophical fields, but without any knowledge in this area, and also with the idea that is still in the generation that it's maybe a little bit older than me, but even in my generation, that we had to deal with a totalitarian communist regime, with all the implication that maybe people now in the West, they are not looking in, because still people, especially on the left, not all of them, they would like to acknowledge how the communist regime was transformed how the communist regime was in practice.
To delve into the topic of human rights in particular, I was interested, amongst the ruling class, let's say in Romania, was it that there was a lack of knowledge about human rights, or was it that human rights were seen as a sort of tool of Western propaganda, or some kind of combination of those?
No, I think that among nobody Western propaganda was not there anymore so much, or maybe I don't know, maybe few people related to the Politrubo, the political bureau still believe. As I told you, I think all the political science studies show that we're starting with the mid-60s. There were very few people still believing in the socialist idealists, and we have a very famous, by Václav Havel, said something very interesting, that the beliefs of the population in the communist regime was like the grocer who was obliged to put in his showcase in every moment proletariats for all the countries are united, because otherwise he will not be able to live his life. But he didn't. He was completely out of this idea. So nobody believed in Western propaganda anymore in the among the population. But we didn't have access to this because censorship was very, very strong, and the books that we had belonged to the areas that were not dangerous to us. Even more, the books that were against the revolt. This is the reason why I said we were told that aesthetics has to prevail upon ethics. That is not enough sophisticated for us, being such a sophisticated intellectual, to go on streets and fight for liberty, because this liberty is for nothing. Human rights are for nothing, because the human being is inside. The human being is designed, as Heidegger said, as I quote all these philosophical, very high, but all of them against action, all against human rights. So the fact was that we have not had this books. They were really under a very strong censorship. So in this sense, I think maybe the Charter 77 and the Czech Republic and the other countries were a little bit more developed than us. Of course, we knew the documents that were agreed by the communist regime, and we had in the constitution a lot of human rights, but everybody knew that this one was on the paper. So nobody really, and as far as this was explained in propaganda terms, nobody took this into account.
It's very interesting, that distinction between the intellectual understanding and then the physical going into the streets and calling for the rights to be observed. And what I wonder, with that experience, when you then later became a judge in Romania, particularly during this transitional period, what were some of the challenges that you faced as a judge in particular, and how you managed to negotiate those challenges?
Yes, so the challenges were, the first year after the fall of the regime, there were very enthusiastic years. There were years where, at least the first ones, or the first period, nobody understood that it will take us so long time to join the democracies, the established democracies. And they were, of course, transformation in terms of law, a lot of transformation in terms of law. It was a lot of legal chaos, if I can, because it was a new regulation with the old one we had, and we had again to do things by ourselves, because despite the fact that I was a very young judge, 22 years old, I had to chair very difficult trials, because it was not time. We had to catch up. It was not time. So we had to find our, sense of justice in all this legislation, all legislation that was not changed yet, with the new rules, with the new principle. To a certain extent, it was an interesting exercise. It was a very creative exercise, an interesting exercise. And indeed, since we were very few, this is something, very few people who graduate the School of Law in Romania. I graduated the School of Law in 1989. We were only 160 people in whole Romania, so very few. We had a lot of work to do. So I think they were interesting year, building us tower, thinking that we are going toward justice. But indeed, afterwards, I also experimented a kind of justice going a little bit into the corruption mechanism, and this was the dark side of the moon when I decided to leave the judiciary and go to join the academia in mid-90s, by the way.
And you've had many transitional phases, and transitioning, I can imagine we may be skipping over some steps, but transitioning from being a judge and an academic to then working in the UN, and you've worked in the UN in various capacities that we've seen. But one question that comes up, and I think this links to your time at the Human Rights Committee, for example, is that there are very limited enforcement aspects to, for instance, the Human Rights Committee in terms of seeing its decisions implemented by governments. And how do you find this to affect the practice that you undertake at the UN? And what are your views on this in terms of decisions and enforcing those decisions?
Yes, I have to say that for me, UN Human Rights Committee and also the other UN bodies that I've worked, but now I'll refer to this very important treaty body, I do not see purely the enforcement as if you wanted to say, the application and the execution of our decisions in the communication. I don't think in the individual complaints. Of course, if we look to this side, we don't have so many. We don't have such a good record. UN Human Rights Committee doesn't have such a good record, and we have the special rapporteur every year coming back with the list and saying this communication was not executing, this was not executing. But I do not take things only in this respect. This is a face of the Human Rights Committee, a face, but I think one face. There are other two major faces of the UN Human Rights Committee, like all the other treaties bodies, that are very important, and I think with them we are doing better. And the first one are, of course, the reports of the countries. You know, we have reports every 4 or 5 years, depending when the Human Rights Committee are asking a country to do the report. And it's not comfortable for a country to have the same question addressed twice or 3 times. And if sometimes, you know, they do not execute our communication, because as you know very well, not all of the countries, they sign the protocol and everything related to the communication. But I see and I saw in time quite a lot of progress from the report to another, because you know, where a country comes and the report comes, they cannot come with the same assessment, same situation of human rights. They have to do something. They have to do a legislation. They have to implement. So this is one side where I see progress, and I will see even more than this. I think that what is very important in all this process of reporting towards the UN treaty bodies, and even previously, because I was in the subcommission, as you mentioned, now it's done, but it was such an important mechanism of human rights. I think when we are doing the reports, where we put questions, we interact with NGOs. For me, this is the key, because through this, I think we had a better understanding, and the way that you are doing a kind of not classical enforcement, but a way that you are finding your way to convince, a subtle way, a soft way you are finding your way to convince the state to improve the human rights. So this will be the first one, I think. And also what is very important for the UN Human Rights Committee, I think that the general comments are keys of the Human Rights Committee. So even though, as I said, sometimes maybe we have only half of the individual complaints that are enforced or like this, but the fact that the decisions in the decision taking in this communication are afterwards in the general comments, and the general comments of the Human Rights Committee are such an important piece of quasi legislation in for several other bodies of the UN and for the courts in human rights, and also is fundamental. So I will think about these bodies as being quite efficient, maybe not in a very straightforward way, maybe in a more subtle, more indirect way, maybe to act.
And from those UN bodies, we can transition to, again, a different type of body with a different mandate, which is the European Court of Human Rights, where, of course, you served from 2013, I believe. And in that body, during the 2010s, let's say, it was a challenging period where there was a huge number of cases before the European Court. There was some significant human rights questions and broader geopolitical challenges arising, particularly as we still had this period of counterterrorism actions and a lot of security actions coming up against human rights protections. So we'd be very interested to hear some of the issues that you worked on in particular that stand out to you, and how the court and how you dealt with some of those challenges.
Thank you very much. Yes, indeed. It was a period after the adoption of Protocol 14, where we diminished the case law of the backlog of the court. At the same time, I think, the years that I served at the judge at the European Court of Human Rights, at least at a general level, because being a national, so this I will tackle, being a national judge from a country with a lot of cases like mine, change a little bit the perspective. But at the level of the court, indeed, I think, there were years of subsidiarity, there were years of subsidiarity with, if I have to say, all the positive and the negative side. And because you mentioned this, I think also that I have written about this as well. I think, all this agenda that came more with Protocol 15, but Protocol 15 was entered into force lately, but it was a mechanism. Subsidiarity was a fundamental mechanism of the European, is a fundamental mechanism of the principle of European Court of Human Rights. But what happened in the years that I was there, it is that really there were this influence very much of, for instance, testing. A lot of tests brought from the Anglo-Saxon realm of law were brought there, and we have, for instance, a very interesting saga, as we call the Ibrahim saga, relating the right to have a lawyer at a certain stage of Article 6. And we see that this was very much criticized, the saga, because afterwards we have other case law that follow this, like Bös and Simeonovi, and we see really that the court, as at the level of the Grand Chamber, diminished the rights that the accused used to have. So bringing cases at the level of the Grand Chamber, formulating tests at the level of the Grand Chamber, diminished the level of the protection of human rights. So you're using also subsidiarity. So I think these were a little bit the years where we were there, and that we have this, I think, technicity was very much used in order to lower the standards. But still we had areas that were where our living instruments were still there, and especially I was particularly interesting, and there were areas that about the rights of vulnerable people. I think that, for instance, the question of violence against women has extraordinary evolution during this time, even in the space, even in the cyberspace, with even case law relating to my country, as other people with vulnerability, with mental health problem, with these were areas that maybe they were less touched by this tendency that was to a certain extent imposed by the states, that we are going too far with the question of the living instrument. So still there were areas where the court, of course, we can quote here also other areas that were developed by the court in this period, like the cyber security in the famous Big Brother case. Also, we can talk about the case law in the area of independence of judiciary. Again, very important case law of the court, especially in the cases regarding Poland. Yes, this was area where the court was quite active and went into this classical role of the living instrument, but on the other side, as I said before, there were years of subsidiarity.
Well, one question just to prompt you a little bit. At the European Court, if I understand right, judges can and do frequently hear cases from their own country of nationality, whereas in my working group on arbitrary detention, we recuse ourselves automatically if it's our own country of nationality. And which one is right? Which one's correct?
In the European Court of Human Rights, we have the rule that we have to have the national judge sitting in the composition. So it's the opposite of the UN. I will go back. And why? Which is the reason why we have these regulations? Because the European Court of Human Rights is going really very deep into the legislation of a country, and we say that without a national, we cannot do this. But on the other side, I have to say that the regulation of the court are very much inspired by the ICJ, the International Court of Justice. And as you say, there, every time we have a national, or we can have a national sitting where it's about our country, and there we don't talk about legislation anymore. Indeed, in the UN, you have the opposite. In the UN Human Rights Committee, we have the opposite. But the level that we are going there, it's not the same. I have to say that normally when you are sitting a national judge, and also because also not only the national judge, also you are judge rapporteur in majority of the cases of your country, I have to say that you have to take your role with quite a distance in order to have credibility, because if you are having some solution that will lack credibility, you cannot sit in this position. So it will be a kind of how to say peer, not to put peer pressure, but it will be impossible. So the role of the national judge is to really to present in an objective way the situation. We have also the lawyers, the registry. If you ask me, for UN, I will not change the rule. I think for UN it's very good that the national will not even hear the case. For the European Court of Human Rights, I think that every colleague will agree with me. It will be very difficult for the countries to judge, especially because we have a huge part of national legislation, and you tend to do a lot of mistakes. I don't think that this is a kind of negative things about the European Court, because of course you can see there, and if you, for instance, if you see there are example in the history, you don't see any violation in the case of your country, your position is not going to be taken into consideration. So for the UN, I'll keep the rule. For the European Court, I will see with difficulties how we cannot have somebody who is knowledgeable about the legal system.
Well, thank you for the explanation there. And then you've mentioned, obviously, the European Court and the difference and similarities with the ICJ, but I want to make sure, of course, we bring ourselves to the present, to the International Criminal Court, where you've started at a particularly fraught time with a number of new situations around the world confronting the court. And I'd like to ask you, what do you see as the most acute challenges for the court as we stand here today, and for its success and potentially even its survival as an institution?
Yes, indeed, I think the most important question of the court is the survival in this moment, because as you know very well, and as the president of our court told the ACP during the last 2 weeks, when you attend also the meetings, is the question of our survival. We have a lot of threats toward our courts. We have 6 colleagues plus the prosecutor that are under arrest warrant for a particular state that I will not mention, but we know about what we are following their decision in other cases. And as we know very well, a certain state they had certain initiatives to impose sanctions on our court, and I think the court is very concerned about the survival in this moment. We have a lot of threats, these kind of threats, and we have cyber attacks, of course, last year. This is one of our main concern. The second concern, I think, is the cooperation of the states for us. As you know, we have a very big crisis because a great number of the arrest warrants are not executed, and we cannot judge in absentia. Now I am a member of the composition of the CONI case, where we try at the level of the pre-trial to do the confirmation of charges for in absentia, but this is the first procedure. This is something that is quite difficult in legal terms, and the main question that we have in this moment is that we have a kind of lack of cooperation of states regarding this arrest warrant, which determine the fact that we cannot go to the stage of confirmation of charges maybe with the CONI, but even if we go, our statute is limited, is not like the Lebanon tribunal. So it means that at the level of the trial, we are going to have very, very few cases in the future. I think this is another one of the biggest challenge that we have nowadays as well.
And in relation to the Joseph Kony in absentia confirmation of charges hearing that you've just mentioned, I mean, this obviously is a very novel and interesting procedure, because it will be, if I'm not wrong, the first time at the International Criminal Court that they will have such a procedure. Do you see it as an opportunity for some fascinating legal developments? And if so, what type? Or do you think this could be a very challenging procedure when you don't have an accused there to advise the defense counsel, who typically would talk to their client about how to approach this? So I'm interested in your views on this procedure.
Yeah, this is the difficult question for me. So, of course, indeed, I will talk theoretical about this. Of course, since it's the first time that we are doing this, we have a lot of issues related to this question, and the main issue is the issuing the fairness regarding this question. I cannot talk more because these are but indeed, as I said before, and everybody knows, there are this. Yes, we try to do our best in order to assure the principles of the status of Rome. I'm very reserved in this position because I think in this court normally judges should be we have the duty of to being reserved, but in this court I think you have to be even more careful than in all other courts.
Yes, thank you, and understandable.
Yeah.
In terms of comparing the legal culture, as you allude to, at the European Court versus the International Criminal Court, and particularly now at the International Criminal Court at such a pressured time, do you see differences in the culture, the judicial culture, the way in which the practice is carried out, and if so, what differences have you seen?
Of course, this is a court that is composed by states that all over the world. So to a certain extent, the legal culture is and the legal environment is closer to the UN one comparing to the European court. So different I would say different legal systems, as you know very well. One of the main questions that we have the two systems, Anglo-Saxon and the civil system, that two are there, and we have to deal with them. And also I think that it's maybe the we are going even deeper in the legal culture of every country, because normally our colleagues from the UN, majority of them, they come either from international human rights or perspective or international law. But here really we have criminal lawyers. Of course, they have an international law background because otherwise they couldn't be elected. But they reflect deeply. Their legal culture, and I found this very interesting, and dialogues very interesting with them. I have to say that yes, I'm quite happy to go back to a universal milieu. Yeah, after the years that I spent in European court, not only because I was also member of several other treaty bodies at the level of Council of Europe and European Union as well.
Thank you. I have two more questions or areas to ask about. One, you mentioned the cyber attack on the court, and I'm interested in today's climate where we have these rapid advances of technology and artificial intelligence coming in, and also disinformation, misinformation, and how you as a judge and the institution more broadly is navigating these waters where information is sometimes murky and unclear and maybe manipulated or created through deep fakes. So how you're managing, and then I'll have a final question after that, more broad question about coming challenges. So also looking to the future, but further prospects. So firstly, on the disinformation area, whether that's been an issue and how you've addressed that.
I think that we, as you know, at the level of the pre-trial, we are dealing with the file that the investigation is done by the OTP, and I think that we have not. I think we have now the possibility to for all the corroboration of a lot of evidence that we have to avoid this. Or to avoid these questions. As you know very well, we are using the new technologies even during the trial when there's the reconstitution of certain proofs. We started in this direction. I think what is very important for us with the new technologies, with the cyber technologies, is on one side to be a way of to try to distinguish in the evidence on this kind of possible evidence, that possible presented evidence. On the other side, to know to use the technologies and the new technologies in our favor for the trial, to construct and to have a not only deeper but also faster way to investigate, because as you know very well, this is another criticism that was addressed to the ICC in the future, the timelines of our trials.
And then turning more broadly to the future and constructions such as universal jurisdiction, allowing trials in domestic courts for these atrocity crimes, and other potential mechanisms being created. We've heard talk of a potential tribunal for aggression linked to Russia's invasion of Ukraine, for example. And how do you see the coming decade of ICC operations in that broader context of international criminal justice?
Yeah, now I have to say, of course, the disclaimer we have that we are talking in own capacity. As you know very well, it is a tendency at the level of the ICC, I think, try to have all this mechanism into the ICC body, because already we have a body, we have a court that is financed by the member states. They have a lot of capacities, they have a lot of in the field as well. So I think the tendency is, and the reflection for the part of the court is to have everything with the court. On the other side, regarding especially the question of aggression, we know very well that the Kampala Agreement has its limits and has its states that are they are signing and ratifying, and that we are not going so far, especially because we don't have the equivalent of Article 12 of the Statute of Rome. So we don't see practically what happened. So as you know, as well, you know better than me as well as me, we at the level of the UN now, we are into these two perspectives, special tribunal, but if special tribunal, why we have ICC and Kampala? And with this question, we are still debating. I think even I don't see many progress until I think the beginning of the war there, where I remember that the first article published by Philip Sands, even afterwards of the events appeared in the financial trial regarding the tribunal, because of these things, because on one side you want to revise Kampala, you want to make, but how long it will take? And on the other side, you think, why to create new tribunals when you have a mechanism? And we are into this institutional dilemma. Of course, there are political dilemma that you understand as well as I understand, but we are talking in legal terms now.
Thank you so much for all the candid and open answers to the range of questions, including your own background, but also the practices of the institutions that you have experience in. On the last question, I think the events in Syria clearly relate to the same considerations, albeit in its own context. And so that opens up, and I've already seen a number of publications raising questions about accountability, quite rightly. But of course, having worked at these institutions, I know that it's not an instantaneous thing, even when you have jurisdiction, let alone when you don't have a direct path of jurisdiction. So with those questions, and thank you so much, I will pass to Carla, because we did promise that we would open up to a broader range of questions. So over to you, Professor Ferstman. Thank you.
Thank you so much. And thank you both. This has been such a fascinating and really rich discussion. And Judge Motoc, I can say you've been really generous with answering all the variety of our questions. But sadly for you, it's going to continue for a little while longer, because we have a whole list of questions growing for you. So hopefully you can humor us a little bit longer.
Yeah, very pleasure.
But maybe I start with one question from me, and this relates to something that you said at the beginning of your remarks, and it has to do with your time as a young judge in Romania and you said we had to find our sense of justice. And that really resonated with me in terms of the challenges that so many countries face at the time of a transition. But then it got me to thinking, well, I imagine this is actually something that as a judge, you will need to do in all contexts. So I imagine having that sense of justice and applying it, there will never be a situation where rules can simply be followed. The sense of justice is so important. So I just wondered whether you could reflect on that.
Yes, you are so right, because I was a judge for 6 years. Afterwards, I joined academia, and UN also very, very young. I joined when I was 28 years old as an expert. But what I want to say is that the period when I was judge at the first instance in my country, I told you the 22, starting with 21, almost 22 years old, are very important for me. I think for this sense of justice that you mentioned, because sometimes, you know, you are looking to the legislation, you are looking, and when you are there and you have such a broad context with changing context, you have to have this feeling by yourself, either that, I don't know, this can be a talent as well, this can be the result of your readings, this can be the result sometimes of the empathy. We have a whole legal philosophy about this. Indeed, this stayed with me all my life. On the other side, what stayed with me all my life, and is very important, is that even as a member of the UN Human Rights Committee in the communication group, where I go back to files as well, you know, domestic files, and afterwards, of course, European Court even more, all the time, I look back to the files. It means for me, as I don't know if we have in English this expression, I will translate from French, which is my first foreign language, except Romania. I have to feel the file. So it was so, I remember when I started in the communication group in the UN Human Rights Committee, I had cases in Russian. Of course, my Russian is not good. I have never learned in school, but some they were in English, but I asked for the file, because even the part in English, the original file in the country, they give me a sense of the file. And all the time I proceed the way. So you are so right that this is a kind of education that maybe for us gave us the sense of justice in a way that sometimes people that have a lot of legal education in different, you know, realistic and other school of legal philosophy, or maybe sometimes us and as human being we can have. This was very useful, and thank you very much.
Thank you so much. I'm going to turn to a question from one of our LLM students, Abdullah Arif. How can international human rights mechanisms and institutions be strengthened to hold totalitarian regimes accountable for mass atrocity crimes, particularly in contexts where such regimes demonstrate blatant disregard for human rights norms? The Islamic Republic of Iran is an example.
Yes, this is
none of the questions are easy.
Yes. No, the question is that the questions are not complicated for me. The problem is that it's complicated that I am a judge, and I cannot express myself because I am limited. Because otherwise, the questions are not. But yes. So I will try to answer as much as I can with the reserve. I think these are really the most when you face such a regime in terms of the UN as such, you can have different bodies you can have also, because you have, I don't talk now about Iran because I cannot talk about concrete countries, but I would say that if we see such kind of regime in general, we see that we have a concentration of UN mechanisms, starting, if it's possible, with the Security Council, if it's functioning, that you know that in the 90s, 20s and something started to be more inclined to human rights, if it's possible. Otherwise, we manage to go to the General Assembly, to the resolution. We have a whole range of mechanisms that are acting for a country. What they obtain at the end is very difficult to say, you know. It's sure that in my life, and again, I don't talk here about particular country because I cannot talk, in my legal life with the UN especially, which is very long, almost 17 years before I joined EU, European Court, I saw countries that they became pariah in the system, but this is something, it's another question. Sometimes mechanisms are not working, we have to say, and only politics works, what we can say. This is the truth.
No, thank you so much for that. No, thank you. And now a question from one of our colleagues, Dr. Carla, reflecting about her own childhood. Professor Lee Yippee writes in her book, Free, about how the end of the regime did not materialize in egalitarian and substantive freedoms in her native Albania. What lessons does Judge Motoc draw from the impact that the neoliberal transition had for material conditions of freedom in Romania after the Ceausescu regime?
Yes, this is indeed a very interesting question. I know the writings that she referred from Albania. Indeed, situations are quite different, I have to say, because some countries of the Central and Eastern Europe, they belong now to the EU and to NATO, and these are fundamentally different. Indeed, as some now of the critics of the new regime said, not only the transition, because sometimes the transition ended, but when we face a capitalist system, of course we have the inequalities. So for somebody who had not lived properly, and for younger people who had not lived the totalitarian regime, maybe they have the illusion that it was an equal regime. No, it was not an equal regime. And if you look to something very obvious, the equality between men and women, this was a disaster. So women during the communist regime, they were worse treated than in the traditional regime. So on the paper it was equality, on reality they were really very, 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 very treated. Sexual violence, everything was really there in huge tones. But on the other side, indeed that capitalism and transition and all of these, they are as they are. But I have to emphasize something, that our system of protection of for instance, health rights in Central and Eastern Europe, I don't know Albania, are even now are more protective that in other countries. But indeed, of course, as we know, we can criticize capitalism with all the facts that are there, but it is in terms of not capitalism, but society that follows in Central and Eastern Europe, especially with that join EU and NATO. There are countries with a lot of freedoms, and comparing with what we had before.
Thank you. And we have a number of questions which relate to in absentia trials. And here I know that you will probably have difficulty to answer.
Impossible to answer to the.
Impossible to answer.
Yes, no, I cannot answer to these questions.
No problem at all.
Because I sit in the case, and yeah.
So I think we can just say here that this is generating a lot of interest, and we really look forward to following what the chamber will do.
Yes.
So to those who asked questions about in absentia, we're going to pass on those for now. But I will also ask you a question posed by my colleague, Professor Gilbert, who asks, his question is to you directly. You have an incredibly impressive record as a human rights lawyer in so many different aspects, but now you are a judge on the International Criminal Court. When you're considering the individual criminality of the accused at the ICC, how is the process different from human rights adjudication in relation to state violations? And how far did all the work on human rights bodies prepare you to act as a criminal law judge?
Yes, I have to say that I started as a criminal law judge. I started my career, afterwards, I think the case law, at least at the European Court of Human Rights now, 70% of the case law came from criminal law background. So you have to be quite a good criminal lawyer in order to understand the case, even if there you are facing a state. I don't find the transition so difficult, maybe because not at all, I have to say. I found because maybe I was UN Special Rapporteur before for DRC, so I dealt 4 years with massive of crimes against humanity, war crimes. And because, the process of selection of the judges of ICC is a 1-year process, very demanding, with a lot of examinations. And when I look to the file, yes, there are different files comparing to the final files. If you were the last file of the European Court, when you look to only human rights violation, here we are looking to the crimes of the individual. I'm sitting in pre-trial, so I'm looking to this, of course, we have to keep some notion, very important notion of from human rights. The basic one being the fairness, the right to the presumption of innocence, and all this is very important, and somebody keeps this in mind. And also, I think what is very important, what is fundamental for me in this capacity that I have now, presiding pretrial chamber 1, is the question that I'm still an international lawyer. I consider myself an international lawyer. So questions of jurisdiction are fundamental as well, and these are related to international law, pure international law, pure, what stays for general international law.
Thank you so much. And maybe an additional question, which is really about how the court as an independent institution navigates the political challenges. And you may or may not be able to answer this, but perhaps there's some reflection you can bring. From a practical perspective, is human rights law really enforceable internationally, considering that sovereigns have their own jurisdictions and can apparently ignore any judgment made in International Court of Justice, ICC, ECHR, etc. So how do we deal with these sovereigns?
Difficult to say, Today we have to see how I will talk now about the ICJ because it's not it's not my court. So ICJ, as we know very well, in theory, where a decision of the International Court of Justice is not executed, we can go, the Security Council that can intervene with Article 96 and can mend to the execution of this decision. In the past, we had this done when the Nicaragua decision were not executed. That we know that they were not because we have the veto. But it's difficult to say what we are doing, because I think we have now a period where more, and again I will talk for the ICJ more, where courts are very much, look at the ICJ now, so much involved in a lot of very important issues. Before it was a court, very much, of course, the limitations are very important as well, but they were doing mostly the limitations, territorial maritime, the limitations. Now they are doing consultative opinion, they are dealing with genocide, they are dealing with all these, they have a huge number of cases pending, and indeed, we don't know what they are going to do if these are not going to be executed. We don't know what because this is a period that it was never before. Even if in the 90s states start to trust the International Court of Justice even more than before, because the end of that we don't know. In such a period like now we have not had before.
Thank you. And we're coming to the end of our questions. So just a few more that I'm going to raise. And one is from Ms. Rose Gueda, who asks, given the variety of different nationalities that are on the courts, how do judges collaborate to figure out how to deal with international issues like women's rights that are highly linked to tradition and religion?
Yes, but you have to take into account that we are the only international court that has a majority of women in this moment. And I have the feeling that, my colleagues coming from countries that have not really have the right of women developed, including our president, who, by that time in Japan, it was so difficult. But the others, they became judges in societies that there were so few judges, and afterward they were nominated. I think, that something is there in common of this fight that almost every of us we have to have with our societies and around. And I feel that we have a common language, a human common language. Sometimes what is more but I don't sense so much. I think at the beginning, sometimes it was more difficult. It was the different legal tradition. But now, where we sit, we try to explain, because everybody try to have a certain legal experience. And when you do a new composition, you say, no, me, I was more used to do single judge. You are, but talking about women, because this is fundamental, we are the only court now with majority of women, and I feel we have this common sense of the huge fight that some of us, especially, I don't think so much me coming from Eastern Europe, but some of my colleagues had to do, being the only woman sometimes in a lot of arenas. Yeah.
Wonderful, thank you. And finally, and this takes us right back to the start of the discussion, to your Romanian background and your Romanian judicial background. And we've had a number of questions. How has that really impacted on you as your career has moved forward, coming to the ICC? Do you find that you're referring back to your Romanian legal backgrounds?
Frankly speaking, not so much. I refer back to the practice because I was educated between 1945 and 1989. Afterwards, I studied in France. So public law was not really studied by the time, because it was replaced by the propaganda of the party. Afterwards, not so much the studies. I told Matthew from the beginning more. I think the things that I read by myself, more my literary formation, my philosophical formation during that year, artistic formation during that year, that opened my mind to, I think, to all these other horizons. Yeah, but I cannot say I consider myself to be an autodidact, despite the fact that I was, yes, because afterwards I went to France, but I studied only postgraduate study, master, PhD. I went to the US there. I was I was teaching directly or having, post PhD programs. Yeah, for me, for myself, not so much legal education, maybe practice, yes, in Romania, because, during these very shaking times, you are adapted to important things that happen afterwards, and you start to have courage. As UN Special Rapporteur, I had to have a lot of courage in DRC, but not so much the legal formation, but the other one. So I feel very Romanian in conjunction with all the philosophers, with all the intelligentsia in my country. Yeah.
Wonderful. Coming from a university and having all of the students listening in on this amazing discussion, I have to say that this has been really inspiring. It's so inspiring to see all the variety of twists and turns that you've taken with your career and the amazing ways that you have applied human rights, applied international justice, and we can't wait to see what you're going to do next.
Thank you so much. Thank
But
you.
it's been such a
It was
pleasure.
a pleasure to have this talk. Thank you, Matthew, for the question. Thank you, Carla. Thank you, students, for the question. And unfortunately, I couldn't be there in present, but this is life nowadays to our court. So I hope to see you soon in other. And I wish you good luck with human rights and everything when we stay in touch.
Thank you so much. And we hope that we'll have you here in person. That's on some other
Thank
occasion.
you very much. Thank you very much.
Thank you.
Thank you so much. Take
Thank
care.
you, Matthew.